even know how the system works. But when I first came I encountered her in 2006. I needed to receive a lot of guidance as the person who was the first person to be in the forefront to begin reaching out to the victim, because the war was in existence. So security was at its peak. I needed to go through a lot of vigorous training of personal security, one. And two, the security for victim whom I need to reach to them to participate. And third, to keep their identity during and even after the trial, because these are high-profile cases, which is highly sensitive. Those who have participated, even as we speak now, we still need to protect their identity to remain intact, because you don't know what can happen, because those who have committed atrocities, they are relatives. Ongwen comes from the same community. Koyelo comes from the same community. Yeah. So you don't know what their relatives are thinking.
Yeah.
So even as we speak now, we could not even quote directly the names of witnesses, the names of those who participated. So what we share in common is that the guiding principle of victim protection, victim participation, and access to justice need to apply to both International Crime Division and International Criminal Court. What we appreciate as a victim of Uganda is that ICC helped to build the capacity of the domestic court, to help Uganda develop a judicial system, a wing which can handle international crimes.
Okay.
Because it would be very encumbersome for victim to be traveling a long distance like because there are a number of victims. In fact, when we talk of victim participation, there can be over 500 who have applied to participate. But when it is nearer at home, like this one, you have given them access. They can even just get boarded to come and witness. So that has been the benefit. When the case is, before the case is going on, a lot of sensitization takes place. This lady, ever since she came, to date, has always been in the field. It has helped to build the capacity of both the domestic court and the international wing. Because sometimes they do training even to lawyers who are participating in the domestic trial, like International Crime Division. So we have learned out of it.
Thank you so much. I'm going to connect this with what I have here. To you, Maria. In the Ongwen case, the ICC has moved into the reparation phase. What types of reparations have been ordered, and how do the measures aim to help victims rebuild their lives? Yes, I want it to connect with what Mr. Holmes has just told us. How do these reparation measures help the victims rebuild life back to normal?
First of all, before reparations are ordered, there has to be a trial and a guilty outcome, which we experienced throughout the life of the trial of Dominic Ongwen, arrested, tried, found guilty. At appeal, the guilty verdict was sustained or retained, and the judge ordered a reparation order. It was appealed, and the appeal was overturned. So the verdict, the reparations order, remained as they were issued. This reparations order issued on 28th February 2024 have been the largest in terms of scale, in terms of number of potential beneficiaries, in terms of even money that has been ordered. The judges estimate that close to 50,000 victims that fall within the scope of the case of Dominic Ongwen potentially should receive reparations. And they ordered 52.4 million euros as Dominic Ongwen's liability However, they also found that Dominic Ongwen is indigent. What does that mean? He doesn't have the money in liquid cash. He doesn't have any assets that could be converted into money to the tune of this 52.4 million euro to pay, because the responsibility to pay the victims is that of Dominic Ongwen for the crimes he was found guilty, for the crimes he was convicted. So once this order was issued and recognizing the indigence of Dominic Ongwen, the order encouraged the Trust Fund for Victims, which is responsible for implementing this particular order, to ensure they look for the resources within its assistance mandate to support the implementation of the victims, the implementation of the reparation order. Coming to the next question, what sort of reparations? Yes. The order was very unique. It combined complementary forms of reparations. Deliberately, I want to believe, to address the diverse harm or sufferings that the victims went through. Yeah. So they ordered collective community-based reparations, which is mostly going to look into rehabilitation programs at the collective level by the communities. They also ordered symbolic measures at the community level, the collective level. And uniquely, they ordered another symbolic order of 750 euro for each eligible victim. And we're talking here about more than 50,000 or close to 50,000 of them. The exact number is 49,772 potentially eligible victims that could benefit from this range of complementary reparative measures. Yes. So the reparations, I want to emphasize, are designed in such a way that they are going to look into the long-term physical, psychological, social, and economic impact as a result of the crimes for which Ongwen was convicted.
When was that order passed?
2024, okay. 28th February 2024. Okay. This was the order. And you ask, what does this mean for victims? It means that it's going to look into various spheres of the victims to restore their dignity, to support reconciliation processes, and to ensure that the affected communities try to rebuild their lives after many decades of living within the conflict. So that's why the measures are diverse, and they touch on aspects that are complementary and community-based, apart from the individual symbolic monetary award of 750 euro per each eligible victim.
Thank you. Yes, Ms. Akomo, how have national civil society organizations, what kind of role have they played in contribution to the justice process and rebuilding the lives of the victims?
Thanks, Jordan. I think Chris really highlighted some of the ways in which civil society organizations, and in particular victims organizations in these conflict-affected regions, have been really at the forefront of pushing for justice, truth, and accountability following this long conflict.
Yes.
And I think how Worship highlighted the state in which the region was in right at the end of the conflict. You know, you had a breakdown in the social fabric, you had people who had been displaced, you'd have now people young boys and girls who had previously been abducted, conscripted into the ranks of the LRA, forced to become wives of the rebels, now coming back home, sometimes with children, some their own, others who they picked along the way. And now society had to really find a way of how can we support these people to reintegrate back into the community? How do we reconcile people who have been conflicting? How do we address issues of stigma and discrimination? But also importantly, how do we ensure justice and accountability for these people who've gone through, you know, unimaginable harms, you know, exactly. So right from the forefront, civil society organizations and victims organizations have been undertaking outreaches within these communities, supporting reintegration efforts, whether it's through provision of livelihood support, engaging with cultural and religious institutions to support reintegration efforts, especially for women and girls who had suffered conflict-related sexual violence, who we know really have a harder time reintegrating back into society, providing mental health and psychosocial support. Because you know, when people have gone through such serious violations, it has an impact on, you know, their psychological makeup. That also has an impact in the way they reintegrate. It has an impact in the way they are able to rebuild their lives. And so it's really a critical area. But in regarding aspects of international criminal justice, organizations, including Chris's organizations, which is the Uganda Victims Foundation, have done a lot of work, the outreaches, what he was talking about, reaching out to victims, documenting their stories, their experiences. And all these eventually formed part of evidence that was presented before the court. You know, even just beginning to educate people about what their rights are, the fact that just on the basis of being human, there are certain rights that are guaranteed. So you have recourse to justice. And so you should be able to hold perpetrators accountable. He mentioned the aspect of participation. That's also a way of ensuring that those who have suffered the most also participate in these processes, because these processes would be meaningless if victims themselves at the end of it say, okay, yes, we've had these trials, but I feel so removed from it that it really has no impact on my life. So part of the role of civil society organization has been facilitating this participation, working with institutions like the ICC and the ICD, conducting outreaches and awareness. But also, as I mentioned, part of this documentation efforts. Organizations have over the years done a lot of research, which has formed part of like our advocacy outreaches. This research has also formed part of the way that the courts have undertaken some of their you know, the judgments that they've done. I can give you an example. In the Dominic Ongwen case, when it reached the reparations phase, the courts opened it up to anybody with information that they felt would be relevant to the case, to the court, as it decided what kind of reparations orders to issue, to provide what they called an amicus. And so the International Center for Transitional Justice, ICTJ, the organization that I worked with, collaborated with the Uganda Victims Foundation and conducted outreaches in some of these areas, gathered views and perspectives from victims to hear, okay, what were the specific incidents that they suffered, who were the categories of victims, and if the court is to issue reparations, what kind of reparations would be most meaningful to these individuals. And Maria highlighted some of them, you know, issues of like rehabilitation for those who perhaps lost limbs, you know, being able to get prosthetics, for people who are suffering from mental health issues, having access to mental health support, issues of livelihood, issues of education. That was an important one because the conflict really disrupted life for a lot of people, people who had dreams about what their futures entailed. And so many of the victims did not have an opportunity to go to school, you know, and be able to better their lives. So for many of them, especially for the mothers, they said, for me, what would be important is if at least my child is able to go to school, perhaps get to university, get a good job, then I'll feel that they're in a position to actually build a better life for themselves. Victims also were interested in knowing how can we ensure that incidents like this do not happen again. You know, mechanisms are being taken by states to prevent future violations. Yes. And I think another interesting one was the aspect of exhumations and burials. And I know even in the ICD judgment, it was a novel outcome that came out, but this was an issue that was also very important for victims because people said during the conflict, because of the situation at hand, people were forced to bury people en masse. So you have mass graves in places. There are people who don't even know where some of their relatives are buried, whether they're alive or not. So they said, for me to be able to feel that justice has been served, one of the mechanisms would be if I'm allowed to give my relative, my loved one, a proper and decent burial. And so those are some of the issues that we were able to get out and then highlight to the court. And so even when you read the court's judgment, it takes into account some of these issues. And yes, and we're just two of the organizations. There are many other organizations and victims associations, especially across Northern Uganda and even internationally who were able to bring views based on their experience working with survivors and victims, the research they've undertaken, and that, in fact, I think was then able to really strengthen the judgment of the court.
Take this one as well, the National Transitional Justice Policy.
Yes.
Approved in 2019. What is the importance of its implementation?
So, of course, so I've mentioned how, you know, the situation was like after the end of the conflict.
Yes.
Where now Uganda was in a position where they said, we've had this mass violations of human rights. You have incidences where some of the perpetrators are also victims themselves. You have, you know, some of the basis of the conflict was because some people felt that they did not really feel part of the country. And so Uganda had to sit and reflect on how do we ensure that we repair the harms and the violations that victims have suffered, but also lay the groundwork for peace and justice and reconciliation as a country. Because, you know, you cannot move forward as a country when like certain parts of the country or the region feel removed from what's happening. And so Uganda then, following a process of research, advocacy, engagement between the government of Uganda, civil society organizations, our various partners, developed a national transitional justice policy. And this is a framework that is aimed at ensuring that we lay the groundwork for future peace, justice, and inclusion within our society.
Okay.
Now, within the policy, it addresses issues of like prosecutions. So here we're talking about criminal justice. Criminal justice is just one element when you look at the justice puzzle. Issues of reparations, which have been mentioned. But Uganda is also unique in that we've seen the value and the relevance of traditional justice for many people within our context. People feel more connected to traditional justice mechanisms sometimes rather than the formal justice processes. So Uganda said, okay, we need to ensure that this is part of you know, this process of ensuring justice, accountability, and also supporting reconciliation efforts. Because, as you know, the criminal justice process can be very retributive. It's about punishing the perpetrator. But we realize that we also need mechanisms that are supposed to be about building community, bringing people together, repairing that broken social fabric.
Okay.
So the policy talks about that. It talks about issues of nation building and reconciliation. It discusses amnesty, which was another mechanism that Uganda used at the end of the conflict to ensure that those who had been perhaps conscripted within the rebel ranks felt at ease coming back and knowing that they wouldn't be prosecuted for the crimes that were committed. So for us, the transitional justice policy is really the anchor of what we think can be the best response to issues of you know, human rights violations, ensuring reconciliation and inclusion within our communities.
Okay.
Yeah.
You talked about inclusion and you said some people would feel like they have been cut off from the country. Your worship, you're not cut off, you're still part of us and back to you. What key lessons from the Kwoyelo case, both the trial and the reparations ruling, and help the ICD and other Ugandan institutions respond better to victims' needs in future cases? You're still with us.
Thank you for remembering me.
Yes.
Maybe before I address specifically that question, there's a few things I'd like to highlight from the contributions my colleagues have made. One is Ms. Marian has talked about the transitional justice. It is true that one of the key lessons that we actually learned from this trial is that beyond the verdict, beyond the sentence, then what? Because during our outreach programs, the women, for example, who had had children born as a result of the war would say, okay, Kwoyelo has gone to jail. What do I do with this child? During the outreaches, the issues of the court had, in the initial stages of the trial, said, do not remove these bodies because they formed part of the evidence. So those sites had to be preserved. But we learned in this case that justice means different things to different people. And the court has got to act with a lot of wit and sensitivity to see that those different needs are addressed. Issues of exhumation. Never in a criminal justice system did we think that the court would have to be involved and engaged in making orders of bodies being exhumed for a burial. But in this case, the court did that because that is what justice meant to the people. And for another lesson that we learned during this trial was that you cannot underscore the importance of institutional synergies and corporations, because we had instances where we had to deal with issues of witness protections. We had to deal with capacity building of the lawyers, especially international criminal law being a novel area. And we had to reach out. I think Mary Ann's institution was very significant in that, in seeing that the capacities of the judges were built. New research into this area was done. So that was lessons that as the ICD we cannot forget, because it helped us to understand where are we coming from, what was this animal we are dealing with, which had not been something we dealt with before, you know. And another area I would speak to is the proceeding highlighted the importance of witness protection. In most criminal cases, usually a victim or a complainant is just a witness for the state. And once you finish testifying, you walk. But as my colleagues has underscored, we realized in this case that it was more than that. You had to think, first of all, how do I encourage this witness to speak out? Some of the things and the atrocities they had suffered were so personal, like sexual violations of their body, and most of them had moved on with their lives. They had remarried. How do you pull this woman from the community and bring her and out her, testify? You're going to affect her relationship, which is trying to grapple with. So we had to learn the need for witness protection. Then when it comes to reparation phrase, we learned that, you see, for reparation to be meaningful, there has to be a system in place. As we stand now, unfortunately, unlike the ICC, Uganda does not have a trust fund. And this again goes to what Marianne mentioned. It is very important that the transitional justice policy comes into fruition, into an act, because...
Does it come with a fund, an idea like that?
Of course it has financial implications. And those studies had already been done by the Ministry of Justice, which is the Lines Ministry. But I think it has taken quite a bit of time, because now here is a victim, my brother here, with a very good court order, and then the question is, now what? Because Kwayelo has also been found to be indigent. In our case, the court was very creative that the court brought Attorney General on board. But remember, these are just directions, declarations that the court could make. It does not have the force of law. There has to be the institutional, the government goodwill to see that, okay, these people really did suffer and they deserve, and we're optimistic that those reparatory orders will come to fruition.
Our judicial system,
yes, please.
You talked about the fund, commonly has other challenges, and the common one is case backlog, and it has other issues that explain it.
Yes.
Whenever they point at case backlog, they'll say underfunded, personnel problems, Don't those challenges affect the victim who has expectations of justice?
They don't just affect. It is one of the core challenges, and this is also part of the learning that we learned from this trial. One, first of all, crimes of atrocities requires a lot of patience, because it happens during a time of chaos.
Yes.
Then there is investigation, gathering evidence. Then there's issues to do with witness protection protocols, all that we're talking about funding. Then there's dealing with vast bulk evidence, which needs to be scrutinized, verified, shared, and all that. Then you come to the judgment. Then you have another hearing for reparations. Yes, it does. It can fall within the realm of backlog. Backlog in Ugandan jurisdiction is any case that has taken 2 years. But right now, if you come to the International Crimes Division, you'll find that there are quite a number of cases which are backlog, just because international crimes, even the ICC, the first case, it took them about 12 years to get their final judgment. So now that is an international court that has reasonable access to funding. Now you can imagine a domestic court using its local revenues, local resources. It is quite challenging, but what the key takeaway for me has been that unlike before, we are in a better place. Why? Because now, where we had to spend time doing research, learning, now we have already gone through the knowledge transfer. So any case that would arise today, Uganda court has the capacity to handle it fairly and squarely.
Thank you, Washu. Mr. Ongom, when you look at both the ICD and ICC processes, what aspects have helped victims feel heard and respected, and where do you see gaps that still need a touch from either ICC or the ICD?
Thank you so much. In fact, we appreciated these processes, especially. I want to anchor it on ICC. In my experience, since my childhood, I don't even know that once a crime is committed, even like defilement, even murder, I've only seen that relatives only go there as witness, and that is the end of it. But when I attended this meeting of ICC in 2006, then I get the aspect of victim participation. I had not known it. Secondly, international justice. I did not know how different it was. So that is when we realized that as victim, there's involvement of victims in the trial process, right from investigation, trial process, even the order of preparation. Because as Uganda Victim Foundation, a number of times when trial is going on, we are always asked as victim representative to file amicus curiae. That ones, I move and meet victim, consult with them and get their views and submit it before the court. That's never happened. Secondly, the court sits in Hague.
Yes.
But the field office right in Uganda is capable of picking me and sending me right to the deepest village, whether in Acholi, Lamu, or Test, and I can go and meet one victim like this under proper guidance of the court, and I get their opinion without politicizing it. And we follow a chain, and it goes back up to the court. And the victim, first of all, even before the trial has concluded, is already feeling being valued. You are not only asked and they forget about you. Even today, while we are waiting for reparation to take place, we have a permanent field activity which is going on continuously. The ICC fellows has not abandoned the victim. They are always there giving updates almost every quarterly, I would say quarterly. I have the ICC field office asking me to organize stakeholders meeting where they give updates where I'm saying is standing. We have met with ICD and have tried to adopt almost a number of things which is practiced at ICC. But the challenging is that the judicial process is very expensive. So the challenges which the court asks International Crime Division is beyond that. It's about government in terms of funding, because it is very, very costly. But if you see, even at ICC, reparation is not yet done. But they have a package of what they are calling interim assistance. I piloted on behalf of the, in 2008, what we are calling victim assistance, where we could pick victims and take them for surgery because they had bullet in them. We do take them through cancer. And the principal believed that even before you conclude the trial process, you should not just leave the victim where they are. Once they're sick, they cannot come and witness. So you first need to give them this, what they're calling interim assistance, so that they get ill, so that you counsel them and they're able to participate. We learned a lot in that. When we started participating through the assistance and support from ICTJ in order to do campaign for the development of international transitional justice policy.
Yes.
You find out that a number of that package is full of the views from the victim. Because the challenges which our worship was referring to, the policies was trying to dig out, if we are to completely get ill, what is the needs of the victims?
Okay.
Then we realize we are suffering in so many fronts. There are victims who have been given amnesty certificate, yet they were abducted. Once you are given amnesty certificate, it means you are being labeled as a perpetrator. So that is what also the number of ideas which has got it into the transitional justice policy.
Yes.
So that we look for another way of handling this victim, because they don't feel like they are guilty, yet they were victims. Secondly, we realize you cannot try Ngwen and Kwoyelo traditionally in the North. If you are not yet done with this reconciliation, which they call truth-telling, you are not yet done. So the aspect of truth-telling aspect get into the policy, so that relatives, even if that person is going through sentence, but relatives can come, community can come, then they share their pain, they forgive one another, they come to live as one.
Okay.
So this process has also given us hope that if truly the policy can turn into an act of parliament, which means the traditional leaders are going to participate in such a way that it is recognized. And victim goes to participate when they know they are protected. The other final thing is that you find out that you are also a perpetrator, and you grow up to the ranks of commander. Yet you are abducted as a young person. Those people should also be given time to say their stories. But how do they say it? We need a formal setting. And victims are convinced that if transitional justice policy comes in place, then an act of parliament is also in place. It can help this participation to be on equal what? Equal footing. Okay. We have been pleading that Uganda will also need a day which can be recognized. We still need to know whether International Justice Day can play a role, but we have been asking since when there was a review conference. We are still having a very recent memory that victims were given to participate in the first ICC review conference. We started here, it happened in Uganda from May 31st to June 11, 2010, where victims were brought from all over and they play a football game with ICC officials. President Museveni was on one side, Ban Ki-moon on one side. They still talk about it today.
Okay.
Values, which is given to those who have suffered. Our prayer is,
yes,
if reparation is to happen, we will appreciate. But also, what we are also looking towards, this victim, I say, is this incident not going to happen again? What is coming out of the decision from the International Crime Division and ICC? Is government able to do something which give us a guaranteed future so that this kind of serious atrocities does not happen again? Then we go to the serious war. War can happen in 1 year, but the effect of war to come out of you.
You take decades.
Some people, you kill your parent and you cook it, you eat it. You tell me, psychologically, how many years will it take for that person to come from that kind of
heal
trauma?
from it, yeah.
This celebration give us one happiness. We are not forgotten.
Okay.
We are not forgotten because people tend to begin going to other things and they think the war has already gone silent, everything is already okay. But I'm telling you, people are still not living.
The trauma is still there.
Exactly.
And every attention given.
A big part of
valued.
those who suffered harms directly, they live sometime by chance. Their life are not planned the way those who have not suffered. If it comes to school, somebody who is a victim, you have come from the bush, you have now produced children, or you have come with children from the bush. If today your child goes to school, that is it. But even if they are even at home, there's even no problem. Maybe you are picking your child, you go to look for something to eat. It is not like normal people who program that every day my child goes to school. So that there's a very big difference. Stigma still exists. Calling, name what? Name calling. And there's certain things which happen, which they keep on referring to. Once an incident happened, say like in Uganda here, recently there's a xenophobia which happened
in South Africa.
When these people comes back, there's an intervention which is done immediately in order to repair their life. When the thing happen, they keep on asking. They say there's no money, but we see that they're supporting these people. What about us? It reminds them, that which means sometimes, even if they say there's no money, but some people who suffer, means of disaster is there. When there's landslide, always in mountain areas, there's always a very fast intervention which is taking place. So I call upon that the action which government has taken, if it can be adopted also to reach direct victim in northern Uganda. They have now seen what they are calling cattle compensation restocking, where each family are being given 5 million. Victims are saying, if those who have lost cattle, each household can be given 5 million.
How about those of us who lost?
Their number cannot be greater than the number of the household which
lost human
government has come out to reach. If data can be collected, everything can be compiled, there cannot be so many compared to the number of households, which means in a way, if policy is the one missing, let this policy be, the bill be turned into an act.
Okay.
It was there. Mariam can maybe tell me all our worship. It was in the other parliament. I believe it might have lapsed with the other one? Parliament.
The 11th parliament?
Yes. What we would pray for, we would need to be helped so that they can retable it.
In the 12th parliament.
So that it is renewed in the 12th parliament.
Okay. Ms. Kamara, the confirmation of charges hearing in absentia was unusual. Why did the court take such a decision to confirm these charges, and what has been the impact for the victims?
Thank you indeed. It was exceptional. The first time, and it only should happen in limited circumstances, and it's the first time it happened at the ICC. And it's also legal because it's within the Rome Statute systems, a system that provides that in a circumstance where a suspect is deemed not able to be found, be reached, has been notified of the charges, has been notified of the arrest warrant, in fact, and all efforts have been made to arrest the suspect, and they have not surrendered or the arrest has been successful. That provisions calls that exceptionally judges grant it, and the judges issue several decisions asserting that they are satisfied with all effort, that every effort has been made to arrest the suspect, and he remains a fugitive. They therefore commence the confirmation of charges hearing in absentia. Even though Joseph Kony was absent, his legal team was present throughout the process.
Who appointed the legal team?
It was a court-appointed counsel, because normal procedure is for the suspect, if he is available, to select his defense team.
Yes.
But in the absence of Joseph Kony, in the circumstance, the judge gave the order to appoint the legal team, the defense team of Joseph Kony that represented him throughout.
Can such a process give satisfactory results, really?
But first, it is a preliminary process. Let's get it clear. It wasn't a trial. It's a confirmation of judges' hearing, which at that very initial stage was just for the judges to determine that there are substantial grounds to believe that Joseph Kony may have committed the crimes. And indeed, they confirmed all the 39 counts against him in absentia. Okay. But the process stopped there, because a trial at the ICC cannot take place in the absence. While a confirmation can happen under limited circumstances, but a trial cannot proceed in the absence of the suspect. Okay. And this is why, yes, the victims saw this as a unique process for them, because they waited for more than 10, 20 years for their views and their concerns to be presented to the judges formally for the first time, which happened during the confirmation of charges hearing. And with our interactions with those victims over the years, some of whom followed the process live, either in Gulu, in Teso, in Lango, and different parts within the case locations, there was a sense of satisfaction that this is not it, but for over 20 years, formally, at least someone is hearing our matters, our concerns, our views. Of course, the frustrations are there that this has taken so long. We can only talk about a confirmation, and this process cannot proceed without the presence of the suspect, and then there is no guilty verdict. We cannot get reparations in this case, which frustrates them. But the good side, which they have expressed, is the fact that the court has used innovative approaches within the confines of the Rome Statute to present their views and their concerns to the victims, to the judges. And the important part is the court does not have its police force to arrest Joseph Kony. Okay. It relies on the cooperation of state and other partners to enforce the arrest warrant and surrender. And this is the only way that justice could be complete for the suspect, for the victims, as well as for Joseph Kony to have a day in court, to have the opportunity to present in full his defense, which was not the case during the confirmation of charges hearing. The arrest warrant remains active, and it is for the state parties and other international partners to enforce and surrender him to the ICC for prosecution.
Thank you. About the policy, we are running out of time. Briefly, about the policy, what would be your recommendation to Parliament, the civil society, and the judicial system in Uganda on how it can actually bear real fruits of value to the victims, especially in the line of reparations?
I think, as has been adequately highlighted by my fellow panelists, criminal justice is only one aspect of ensuring justice for victims. Yes. Because when you have a trial, only victims who are directly connected to those trials will actually benefit from reparations. Yep. And as we know, the conflict affected millions of people across the region. And that's why for us, we're advocating, and I re-echo Chris's calls for a transitional justice law. Because while we have a policy in place, it needs a law to give it effect. We're talking about issues of reparations. We would require a reparations fund that would have to be financed through the government system. We can only do that if we have a law in place that actually provides mechanisms for that to happen. And that's why we continuously call for this law to be put in place. I think Chris's submission really comes to the essence of it. We're talking about real people, real victims who have suffered, who continue to suffer, who have largely been left out of the development process. You know, we're advocating for Uganda Vision 2040, you know, all of us reaching middle income. But what we realize is that there are segments of the population who are being left behind. And unless there's a deliberate effort to target them, they'll continue to be left behind. And this will have implications for our development as a country. And the law is one of the aspects that will address issues of reparations. But what we're saying, and I know that a key concern for the government is the financial aspect. But as has been highlighted, if we're able to find resources for cattle restocking, I'm sure there are ways in which we can direct resources to survivors. How can we support our health systems within those regions to support the specific needs of victims? How can we ensure that schools in those regions actually address the psychosocial needs of, you know, these children who were born during the conflict and now need education? And so we continue to advocate for this law to be passed. We think it is the appropriate framework to ensure that all victims will actually be covered. In the meantime, as Chris noticed, there are measures that government can take to ensure interim assistance. NUSAF 4, I hear, is being rolled out. How do we ensure that as NUSAF is being rolled out, there's a deliberate attention paid to victims and also other marginalized populations within our communities to ensure that as the rest of us move forward, they are also not being left behind. I think because of time, Maria has not been able to speak a bit more about the reparations process in the Ongwen case. One of the things that has been highlighted is the ICC also has to fundraise for this reparations process. And you know, right now it's very difficult because all states are focusing on their own issues. But there are ways in which the government can support the ICC's process. So we would also like to see the ICC come in and be part of that process of ensuring reparations for victims in the Ongwen case as well. And similarly in the Kwoyelo case. The court has issued its orders. How do we ensure that those orders are actually implemented so that these victims get a modicum of justice and accountability?
Thank you. Your Worship, this is my last one to you. What next for Kwoyelo? What next after Kwoyelo, and how do you see the future of the ICD's work on international crimes as we wind up?
Thank you. Kwoyelo is not the end of Uganda's judicial journey as far as international law is concerned. As I mentioned, the mandate of the court goes beyond just war crimes and crimes against humanity. The ICD is a specialized court that deals with other transnational crimes like trafficking in persons, like terrorism cases. You heard Uganda has been a victim of terrorist attacks severally in the national parks. You remember the 2010 bombings and all that. So beyond the war crimes, the court has continued to handle many other cases that has come before it. Right now we have about 47 cases. And one might say that a whole court, 5 judges, 47 cases. Oh yes, because the 47 cases, just like the atrocity crimes, are very complex by their nature and requires that. Going forward, we envisage continued investment, you know, in specialized training, digitalizing the court processes, because most of these crimes, if you follow the statistics, terrorists have moved away from the traditional warfare. They use what we call asymmetric warfare. They are online, they plan, they use drones and all this kind of technology. So the court can only be as good as the technology that it is trying to, you know, to understand and be able to give a good verdict. Then I'm also looking, when I listen to the conversations, I still see a heightened need for public awareness. There is a lot of confusion. People do not understand ICC, ICD, criminal division. What is all this?
Yes.
We're not a bunch of redundant. We're not actually a bunch of redundant people. They are specialized jurisdictions. The ICC works at the international level. The ICD is dealing with transnational level within Uganda and outside its boundaries, and all systems complement each other. While we leave the criminal division to deal with the domestic criminal crimes like robbery, murders and all that. But I would also feel very uncomfortable if I left without putting again my voice on the issue of the transitional justice policy. Okay. As I mentioned earlier, criminal prosecution is just one aspect of accountability. But when you talk to the victims, when you work in the ICD, you realize because the court has different jurisdiction altogether. This is a court where the registrar goes and interacts with members of the public. We do outreaches and all that. You hear the voices of the people and you realize that no amount of prosecution, even if government was to put lots of resources in prosecuting, the needs of the people, the justice needs of the people recovering from atrocity, crimes, or conflict-affected areas are very diverse. They cut across policy issues, economic issues, and gender issues. So the answer for anyone who has had an opportunity to read the transitional justice policy is in there. Okay. If only we can have that, even the Office of the Attorney General and all these other government bodies will be able to be facilitated to lend hand. As it is, the judiciary alone cannot handle. We need the Ministry of Water, we need the Ministry of Finance, we need medical, because there's a lot of medical needs of these people, which cannot be legislated. So that is what I see. But in all, or in summing, our objective for us as ICD is very simple, and that is to see that no person undermines crimes against humanity. We do not allow impunity, while at the same time we ensure that any accused person goes through a fair trial. We ensure that victims have an opportunity to participate and appreciate the process, and we anchor the process of the court on the Constitution, the rule of law, and the international jurisprudence.
Thank you so much, Your Worship. Your closing remark, Mr. Kumar, as we
Thank you so much.
in a few seconds, yes.
For this opportunity. I have only 3 things to put forward as we close this session. One of them, that I appreciate both the work of the ICC and ICD. It has helped victims to get organized. They are no longer just individually. In each and every community, you find out that victims have organized themselves into a grouping, so that we can link up ourselves, to the extent that we are even linked to the international victim networks of the world. It helps us to keep on getting capacity building, information, and all this kind of thing. Secondly, my call is that ICC only touches on 4 case locations, and maybe also the thematic crimes of abduction, sexual crimes. But it still leaves a number of victims outside, which will not fall within the jurisdiction. Kwajalo case, I would describe that it touches only on 1 case location, majorly, around, say, like Moro. That one tells you that the victims who have suffered crimes, a number of them are still at large. So that is why our call for a transitional justice policy to be in place is on a very serious note, that every victim, they would, because they don't understand this legal demarcation, they keep on asking, why are we outside? How can they be, we hear they are planning to pay on when victims, 4-year victim, and we are here, we are also what? Victims. But at least at my level, I now understand that the gaps in laws is a big question, because this crime happened in different periods. But transitional justice policy, which is now in place, really need to help us so that this bill really put in place a law. So where government can also use administrative what? Measures. Then the final call is that the field outreach of the ICC really need to continue, because it keeps on empowering not only the victims, but also the community of Uganda, so that we know that we are also responsible to ensure that the reoccurrence will not take place.
Yeah.
Okay.
But government also need to really strengthen and structure and finance ICD on a very serious note as far as the outreach wing is concerned.
Okay.
Then secondly, also the victim what? Section. The way ICC has created victim section, which always take into account. This one can also go a long way to ensure that fundraising is done not only from our local revenue, but some international partner can also support, and also legal aids to be available, because participation, protection of victims for some of this serious crime is very costly and very cumbersome. Thank you.
You're most welcome. Yes, Ms. Kamara, your closing remark as we wind up.
We know that the process of victims' registration to participate in the reparation process is ongoing. Victims are very anxious. They want this to happen since yesterday. But as Miriam mentioned, to use the opportunity to emphasize that even though the trust fund has been asked to look for the funds, the reparation may not happen today or tomorrow. They really have to mobilize the resources to ensure the reparations are executed. And in the decision, the judges themselves are mindful that the money will not be there immediately. However, there will be a need to prioritize the categories of victims. This means even if the reparations were to start tomorrow, the implementation for eligible victims, not everyone will get at the same time. This is where the prioritization comes, and this is why we want to emphasize that the judges said victims who are in dire need, high level of vulnerability, whose current needs are life-threatening, they are the first category that should receive reparation. A second category are victims, vulnerable victims who participated during the trial, and then a third category and a fourth category. And why this is important is to manage expectations, because once reparations roll out, because the trust fund is currently preparing, mobilizing the resources and putting the community structures in place to support the implementation of reparations. So once they start rolling out, victims must be reminded that not everyone who is eligible, who has been called and confirmed that they are fitting into the program, will receive a reparation at the same time because of the prioritization that is there. Okay. And just mere fact that the resources are not available to give everyone the award or the support or the rehabilitation that the judges have ordered in the decision.
We thank you so much, Ms. Akumu. We are winding up with you.
Yes, thank you once again for having us today. And really, in closing, I think we've ably highlighted the importance of criminal justice systems in terms of providing accountability for victims and also addressing issues of impunity. And there we really commend the government of Uganda that set up the ICD and is also a member of one of the state parties of the ICC, because in that way it has really highlighted that justice is an important aspect that it wants to ensure that is addressed. But it's, as we've seen, this is still unfinished business, because only a few people will be able to benefit from these criminal justice processes. So what we require is holistic approach that takes into account the specific needs of victims and designs programs that will best address and repair the harms that they've suffered. Okay. And that's why for us we continue to advocate for the passing of a transitional justice law that will be able to address these issues, and not just for northern Uganda. There's a misconception that the bill is only about the conflict in northern Uganda. But as we know, Uganda has a long history of violence and conflict that has impacted many parts of the country. And there are many communities, individuals that are still dealing with these issues. And so this law will enable us to, as a country, sit and reflect on this journey. There've recently been many calls for a national dialogue. That can ably happen under the framework of a transitional justice law. And so really for us, this is just to continue to advocate for the need for justice and accountability for victims of human rights violations. And we will continue to push for this law, which we believe is an important anchor for these processes.
Thank you so much. Her name is Miss Marianne Akumu. On her left is Miss Maria Kamara, then Mr. Chris Ongom, and Her Worship Juliet Hatanga. Like I said at the beginning, we had a special discussion today about justice mainly as we commemorate the International Justice Day, remembering the day the Rome Statute was adopted, the one that established the International Criminal Court. My name is Michael Jordan Rukomwa, assuming you followed the discussion in any way that it connects with you as a victim, a former rebel, a victim of any kind of crime that falls in the category we discussed. This was the show for you. Thank you so much for watching. Enjoy the rest of the day. Bye-bye. Gentlemen and ladies, please thank you for coming.
Thank you.